G'day everyone and welcome to topic 10 for Laws 11062, Contracts B. My name is Anthony Marinac and this week we're going to be looking at the common law remedies which are available in the event of a breach. So, let's look back for a moment before we look forward. During Contracts A, we started out by looking for about 5 or 6 weeks at formation of contracts. So how do we get to the point where we've got a contract? Then for the second half of Contracts A, we looked at interpretation of contracts. So once we've got a contract, how do we read the jolly thing and work out who's got what sorts of obligations under the contract? Then at the start of Contracts B, we spent a few weeks looking at the vitiation of contracts. So what are the circumstances in which something that looks like a contract might turn out not to be an enforceable contract after all? Having dealt with vitiation, we then looked at the termination of contracts. So we got from the birth to the death of the contract. And we looked at termination by discharge, termination by performance, termination by agreement, termination by frustration, and last week we had a look at termination by breach. Having now terminated our contract, we come in this week and next week to look at the aftermath. So what are the remedies that are available to the innocent party or perhaps to the less defaulting party in circumstances where contractual obligations have not been properly met? Next week we'll go on and have a look at what the Australian consumer law says about how we should resolve disputes where there's been a breach of the Australian consumer law along the way. That'll put us in a position to finish off our study of Contracts B in the final week by looking at something completely different, that is, how contracts operate when the contract is occurring between two different people who are in different countries. So let's rock on now and have a look at common law remedies. What are we going to look at this week? Well, we're going to start out by looking at the key common law remedy, which is, of course, damages, that is, the payment of coin. What we're going to look at in terms of damages is first what the objective of damages is, so what are damages actually supposed to accomplish. Second, how do we calculate the appropriate quantum of damages in circumstances where contractual obligations have not been met. And third, how do we look at what sorts of damages should actually be compensable? What sort of damages can we say, what sort of harms can we say actually flow from the breach of the contract? And in order to work out how we do that, we'll be looking at what we call the rule in Hadley and Baxendale, which is a two-limb rule which tells us what sorts of harm can and what sorts of harm cannot be counted as flowing from the breach. Finally, towards the end of this week, we'll step aside from the common law and we'll have a look at the law of equity, that's chancery law, and look at some of the remedies that equity law can provide to the innocent party in the case of a contractual default. Now, equity law's got a bit of a broader compass than the common law, and so in equity law we'll be looking at the remedies of specific performance, injunction, rescission, and restitution as ways that the innocent party can set things to rights. So let's begin with damages. I think most people have an idea of what we're talking about when we talk about damages. Most of you, I'd be pretty surprised if you've gotten even to this relatively early stage in your degree without coming across the notion of damages. Damages is simply a recognition by the court that the payment of money is one way to repair the harm that has been done by someone who has been in default of the law. So in terms of contracts, damages are there to try to restore the innocent party to what their position would have been but for the breach of the contract. So the first thing we have to understand about damages is kind of conceptual, and that is the fact that the idea of damages is not to punish. Okay, there is a type of damages that is imposed in order to punish, but we're not going to be dealing with that in this course. So for our purposes in contract law, the purpose of damages is not to punish the party. The purpose of damages is just to compensate the original party. This is different, for instance, to a fine that might be imposed under the criminal law. If a fine is imposed under the criminal law, then the purpose is to punish the person who's being fined. So the punishment is simply that they don't have that money to spend on other things. That's not how damages works. It's just about compensating someone for the harm they have incurred. When do we calculate the harm? Generally speaking, the harm is calculated as of the day of the breach. So if the contract is breached, the very first day of the breach will be the date at which the harm is calculated. And so immediately after that, the party might do things to try and prevent any further harm. This is different to some other options. For instance, in some other options it might be possible to calculate the harm as at the date that the case was filed, or calculate the harm as at the date that the case was brought down. Well, in contract law, damages are given as of the date of the breach themselves. Having said that, the court does have the ability to vary that rule if the interests of justice require it. Okay, so under some circumstances, and I'll leave you to have a look at these in the notes for yourselves, under some circumstances it is possible for the court to say, look, not convinced that the right outcome in terms of justice is going to be achieved by imposing damages as of the day of the breach, so we're going to choose a different date. The case you'll be looking for in the notes is a case called Radford and de Frobeville. You'll find that this case was reported in Volume 1 of the 1977 Weekly Law Reports, which of course makes it an English case, commencing on page 1262 of those reports. And look, it's a complicated but interesting little case that you'll enjoy having a look at for yourself. The next thing to understand about damages is that they're awarded on a once and for all basis. So the idea is that we total up all of the harm and we award one lot of damages, and that's meant to take care of all the harm associated with that breach. Except there's a couple of exceptions. The one that I really want you to understand is the notion of a continuing breach. Now, sometimes, if a contractual obligation is not met, the result will be that damages continue to accrue because the breach continues to run. Okay, the breach continues to run until it has been set aside. Now, the case that you're looking at to understand continuing breach is Larking and Great Western Nepean Gravel. This is a 1940 case reported in volume 64 of the Commonwealth Law Reports, commencing on page 221. Now, what happened in this case was that Larking extended the gravel collection / mining rights to the company, and in return for that, they were supposed to do some improvements on the land. They were supposed to erect some fences and gates. They didn't do so. Larking sued them. And you can see that for so long as they continued, Larking's argument was that for so long as they continued not to have those fences in place, the breach was continuing. Because the harm to him was the harm of not having fences and gates. And so for as long as those fences and gates were not there, this was a continuing breach. And so what he argued was that he should continue to receive damages until such time as the gates and fence were mended. What do you reckon? Without reading the case, what do you think justice requires in a case like this, in a case like Larking and Great Western? Well, what the court said was, no way, this is not a continuing breach at all. The court said, we're going to give you damages, and what you should then do is use those damages to go and put a fence and some gates up yourself. Okay, because the damages would be sufficient to compensate the person for the lack of gates and fences, and that could then be rectified, and there's no need for the breach to be continuing. As a general rule, damages are awarded on a once and for all basis. And if you come up in a problem question with something that looks like the damages might not be awarded on a once and for all basis, this should be an occasion for you to tread extremely warily, because this is going to be very unusual and it's actually quite unlikely to come up in any of the assessments that you're going to have to face. Next one we'll look at is called liquidated damages. And you can see on the slide there a pool of yummy, delicious, calorie-laden liquid chocolate, because I'm darned if I know how I could come up with a good picture for liquidated damages, and I thought, liquidated chocolate, that'll do me. Liquidated damages have nothing to do with anything being liquid. Any of you who've studied economics will know that in economic terms, liquidity, or the quality of being liquid, is all about being reduced to cash. So liquid assets are cash assets. The word liquidated is being used in that term here. Liquidated assets occur when the contract itself sets out what the harm is going to be, what the damages are going to be in the case of a breach. So let's say I make a contract with you. The contract is that you will come by and mow my lawn once every fortnight, and in return for you mowing my lawn once every fortnight, I will pay you $20. However, I'm very particular about my lawn, and I really want it to be mowed every 2 weeks. And so we put in a liquidated damages clause that says if you fail on a particular occasion to mow my lawn, then you must pay me liquidated damages of $50. Liquidated damages of $50. Now you can see that if you then failed to mow the lawn, there'd be no need for us to go to the court for an assessment of what the damages should be. We can just look at the contract. The contract tells us what the damages should be. So what do you reckon? Will the courts enforce liquidated damages? Yes, they will, probably. If the liquidated damages represent a genuine and reasonable estimate of the damages, well then the court's going to have no problem. The court won't even engage in the exercise of looking at what the appropriate damages will be. The court will simply say there is a liquidated damages clause in the contract, and that's good enough for us, and that will be the damages which will be given. However, you then have to consider what we call a penalty. Now, a penalty is a liquidated damages clause that goes way too far. Let's look at our lawn mowing case again. Let's say that in this particular case, the liquidated damages clause said that the penalty was going to be $1,000. So you come along every 2 weeks and mow my lawn, and every time you do, I pay you $20. And if you miss one, you have to pay me $1,000. Now you can see that's a bit outrageous, isn't it? Surely the value of missing out on mowing my lawn for a fortnight could never amount to $1,000. It's nowhere near a genuine and reasonable estimate of the damages likely to be suffered. In fact, the reason for that clause and the reason for that number is much more likely to be about imposing a penalty on the party which fails to complete their contractual obligations. That being the case, the court is not going to enforce a penalty. The court will only enforce a liquidated damages clause if it represents a genuine and reasonable estimate. Now, in some cases, and you can have a look at Dunlop and New Garage, which is a case that we've come across many times in our study of contracts already, and you may already be aware it's a 1915 case which was reported in the appeals court reports for that year, commencing at page 79. In that case, the liquidated damages clause in the contract was really quite extraordinarily generous to Dunlop, and the court determined that this was not in fact a penalty, and the court was happy to impose that liquidated damages clause, which to me has always seemed a little bit unjust, because it really does seem to have been quite an extraordinary liquidated damages clause. So really it is going to come down to the discretion of the court in a particular set of facts to determine what is a penalty and what is just liquidated damages. I wish I could give you a better rule to apply, but there isn't. So if you come across liquidated damages in any of your assessment items, there's not going to be a simple rule to apply. What you're going to have to do is give an indication based on the facts that are at hand. My suggestion to you would be that you also deal with what the outcome would be if the court forms a different view of those facts. Next type of damages we call expectation damages. Expectation damages are important because if you think about it, most people go into a contract hoping to do better than simply break even. Most people go into a contract expecting that they're going to get a benefit, expecting that they're going to come out of the contract with something better than what they went in with. Let me give you an example. You're sitting at home one morning and you see an ad come on for an electronic goods retailer, and you see a big, massive flat screen TV and it's on sale. It's on awesome sale. This thing would normally sell for $2,000. Today only you can get it for $800. You rush down to the store. We're in an alternative universe where the Australian consumer law doesn't apply. You buy the TV. You take the TV home. It doesn't work. You take it back. You say, you've breached the contract. You haven't sold me a TV that works properly. They say, okay, here's your $800 back. Is that good enough? Because in your mind, you weren't just going to get $800 worth of electronic goods. You were going to get a $2,000 TV for that $800. So if they just give you your money back, you get an $800 value. If they give you a new TV, you get a $2,000 value. There's quite a difference there, isn't there? That's really what expectation damages are all about. Expectation damages occur where the court compensates a person for what their expectation of profit or gain was from the contract. Now, as we'll see in a moment when we start to talk about causation for damages, it can be quite difficult to prove an entitlement to expectation damages, but it does happen. And Zarnikov and Kufos is a great example. And this is the case that I've referred to in the notes. It's a 1969 case reported in Volume 1 of the appeals cases for that year, commencing on page 350. Now, this was a case all about sugar, all about bulk transporting of sugar, which is why you can see, that's what, believe it or not, that picture on the slide there is what the inside of a bulk sugar ship looks like. Now, in this case, Zarnikov chartered Kufos' ship to carry a load of sugar. They were supposed to carry it to a specific market in the Middle East, and they didn't get there in time. In fact, they were delayed by 9 days. And so the ship owners turned around and said, look, we recognise that we're going to have to pay damages because we've not met the terms of the contract, we've brought the sugar in here late, so we'll pay some damages and then you can sell the sugar and everyone will be happy. Zarnikov, of course, said, no, we're not happy with that at all, because in the meanwhile, during those 9 days, someone else has turned up in this market with another bulk load of sugar. And so now the price for sugar in this market has dropped dramatically. So we don't just want damages. We want damages to compensate us for the losses that we've suffered in terms of the profit we were anticipating. Because we were anticipating being able to sell the sugar at a certain price per tonne. And now we can only sell the sugar at half that price. So we reckon that you should compensate us for the money which we lose as a result. That's expectation damages. Because what you can see is that the Zarnikov's company, they never actually lost anything except 9 days worth of time. They still had sugar. They could still sell that sugar into the market. They didn't actually lose money which they ever had. What they lost was the expectation of being able to make a certain amount of money from that sugar. That's why we refer to them as expectation damages. So how do we work out what is actually able to be compensated? When you first come up against this question, it sounds a bit silly, doesn't it? Because surely any sort of damage which is caused by the breach ought to be able to compensate it, ought to be able to be compensated. But have a think about the example that I've given in the notes. Let's run through it. I've got a contract with a furniture delivery company. They're supposed to bring the furniture to my home no later than 3 p.m. And I've told the company it is absolutely imperative that they have the furniture to my place by 3 p.m. because I have an appointment at 3:30 p.m. I didn't tell them what the appointment was for. I didn't tell them the appointment was for a job interview. But I did tell them that I had an appointment. Time was of the essence of the contract. If you don't understand what that means, go back a few weeks and have a look. What it means, in short, is that being late was not an option. Timing was a condition, not a mere warranty. On this occasion, they've arrived at 3:20, which in my experience is actually pretty close to being on time for a lot of furniture deliverers. So they've arrived 20 minutes late. They complete the delivery, and it's already 3:30 by the time I'm leaving. I'm in a rush. I put my foot down in the car. I blow straight through a speed trap. The police don't give a darn about my job interview. And they hold me up for another 10 minutes while they give me a $132 fine. I'm still hoping to get to the interview as quickly as I can, so I continue to rush. I go straight through a stop sign without stopping, collide with another car and do another $4,000 worth of damage. I get to the appointment and I get told, look, it's okay, we've rescheduled the appointment. And then they look down at their paperwork and they say, oh, actually, we went ahead and interviewed the person who we were supposed to see after you. And we've just given them the job. And the job was worth $80,000. So what are my losses flowing from the late delivery? Well, first there's the $132 fine. Then there's the $4,000 worth of damage to someone else's car that I'm going to have to pay for. And then there's the loss of my $80,000 job. So wouldn't it be logical to argue that my losses arising from those furniture deliverers being late, my losses are $84,132? Now, of course, in reality, that's never going to fly. You're never going to get that sort of compensation for a breach of that nature. But why not? Logically, where do we draw the line? Where do we draw the distinction between what sorts of consequences should be compensated and what sorts of consequences should not be compensated? The answer? We look at a famous case called Hadley and Baxendale. This is an 1854 case. It's reported in volume 156 of the English reports, commencing on page 145, and it's well worth a look. What happened in Hadley and Baxendale was Baxendale was a mid-19th century equivalent of a small transporter, a jobbing transporter, and Hadley operated a mill and contracted with Baxendale to take a broken mill crankshaft to a works in order to have another mill crankshaft made using the first one as a model. You see, the first one had broken, they needed a new one. In those days, things were made by actual craftsmen rather than being made in a cookie cutter factory type situation. They couldn't just order a new part, they had to actually go and get a smith to make the new part for them, which meant sending along the old part so that it could be used as a model for the new one. Now, of course, Baxendale didn't know this, didn't know that the crankshaft was such a critical piece of the mill, didn't know that the mill was going to be sitting idle. And there was a delay. The delay meant that the mill was sitting idle for 5 days. Okay, so for 5 days the mill was unable to be operated. Hadley went after Baxendale for the loss of the 5 days' worth of profit, as well as the damages arising from the delay itself. Okay, so they're going after expectation damages in essence. In response to this, the court set up the two limbs, what we refer to as the rules in Hadley and Baxendale. And these are the tests that we apply to see which damage is able to be compensated and which damage is not. The first step is that we note the defendant should be liable for damage which occurs naturally according to the usual course of things. Okay, so this is damages which flow immediately from the breach. So if the breach involves, say, smoking a cigarette in a hazardous environment, and the effect of that breach is an explosion, then you can expect to have to make good any damage which is done by that explosion, because the explosion is a natural event which occurs according to the usual course of things if you're going to be silly enough to light up a smoke in that sort of environment. Okay, so there's direct, immediate damage clearly and demonstrably linked to the breach. Let's run that test over the example that we gave before with the late furniture delivery. Is me running through a speed trap a natural, direct, is this a natural consequence according to the usual course of things? Well, you'd have to say no. You'd have to say that it would not be expected as a natural and almost inevitable consequence that someone was going to rush out and blow through a speed trap. What about the collision with the other motor vehicle? Is that a natural consequence according to the usual course of things? Well, again, no, pretty clearly it's not. It may have flowed as a matter of logic, but it didn't flow with any sort of inevitability, any sort of natural sort of consequence. What about the loss of the job? Well, again, it's pretty hard to say that the loss of an $80,000 a year job is a natural consequence of furniture being delivered late. So that case pretty clearly doesn't satisfy the first limb in Hadley and Baxendale. So let's have a look at the second then. The second limb in Hadley and Baxendale is that you should be compensated for damage which may reasonably have been supposed to have been within the contemplation of both parties at the time they made the contract. So in other words, if this is something that both parties had on their minds at the time that they made the contract, well then it's pretty reasonable for the innocent party to expect to be compensated. We unpack this a bit by looking at two kind of sub-thoughts underneath the second limb of Hadley and Baxendale. The first is that in order for the defendant, who in most cases is going to be the breaching party, in order for them to be said to have had the matter within their contemplation, either the plaintiff has to have alerted them to the likelihood of the damage, or the plaintiff has to find out that the defendant knows about that likely damage from some other source. Again, let's run a rule of thumb over my late furniture delivery. Did I tell the defendant that it was likely that I would run through a speed trap? Well, no, I didn't, because I didn't know that myself. Did I tell the defendant that it was likely that I was going to have a crash with another motor vehicle and cause $4,000 worth of damage? Well, again, no, I didn't know that myself. Did I tell the defendant that if they were late, my job interview might be at risk? Well, I told them that there was an interview. I told them that I had an appointment. I didn't tell them that it was to get a job. And so they clearly couldn't, it might have been an appointment to get my teeth whitened for all they knew. Okay, so there's clearly no understanding on the part of the defendant or no contemplation by the defendant that them being late with the furniture delivery might cause me to lose tens of thousands of dollars work. So you can see that in that case I wouldn't be entitled to any of those damages, and the reason is because neither of them satisfy one of the limbs of Hadley and Baxendale. I can't emphasise enough that when you are given in a problem question or in an examination a situation where you are looking to see whether particular types of harm are able to be compensated by damages, you must apply Hadley and Baxendale. If you don't, you will get poor marks even if you come up with the right answer. You must apply Hadley and Baxendale. Let's move on now and look at what we refer to as mitigation. For those of you who've already studied criminal law, you may have already come across the concept of mitigation, which is used in a criminal law sense to define or to describe those circumstances in which a person has either pleaded guilty or been convicted, and they are making submissions in order to reduce the length or the gravity of their sentence. In contract law, we use the term mitigation quite differently. What we're talking about in mitigation of damages is the innocent party doing things to offset their loss. Now, there's two types of mitigation that we need to think about. The first is rectification and repair. Rectification and repair happens when you need to either rectify or repair something which is not in proper condition as a result of a breach. Under those circumstances, you will be able to claim from the breaching party reasonable costs which you have expended in rectifying or repairing whatever it is that's been subject to the breach. The case you need to have a look at there is Belgrove and Eldridge. This is a 1954 case reported in volume 90 of the Commonwealth Law Reports, commencing on page 613. Now, Belgrove built a house. He built it on insufficient foundations. He breached the contract by doing so. The homeowners said, well, in that case, we need to have the house demolished. We need to have the foundations rebuilt. And then we need to have the house built again. And by the way, as a builder, you really suck. So I'm going to get another builder to do it instead. And then when I come to pay that builder, you're going to be paying that builder because I've had to spend all this money rectifying and repairing your mess. Belgrove, of course, said there were other options. Instead of demolishing, that they could have underpinned the foundations and done some other stuff that those of you who watch Grand Designs probably understand, but I certainly don't. The court said, it's really not your choice. Okay, you're the one who breached the contract. Knocking the house down and starting again is certainly a reasonable way to rectify and repair. And so the original builder ended up paying the additional costs that were incurred in order to build the house. The second type of mitigation we talk about is mitigation where the innocent party is expected to try to do things to stop their losses from getting any worse. So let's say you have some work done by a plumber, and the plumber fails to connect something up properly, and the result is that you have raw sewage that's starting to run underneath your house. And you have options that you could take which could stop that raw sewage from getting into your neighbours' yards or getting into the drains and running off into stormwater. And you fail to do that. You think, look, this is not my problem. I haven't created this breach. You reckon that sounds like it's good enough? Well, neither does the law. What the law says is that you have an obligation to take those reasonable steps to mitigate your loss. But any steps that you take while doing so become compensable. Okay, so they become a basis for further damages against whoever has failed to do the job properly in the first place. And the example that we look at for this is an absolute cracker. my favourite case in all of contract law. And this is Banco de Portugal and Waterlow and Sons. It's a 1932 case reported in the appeals cases for that year, commencing on page 452. So Banco de Portugal is the bank of record in Portugal. It was kind of like the Reserve Bank here in Australia, and so one of its responsibilities was issuing banknotes. And they decided to celebrate the explorer Vasco da Gama, a Portuguese, and they printed 600,000 banknotes worth 500 escudo each. Now, obviously printing banknotes is a pretty high security business because you don't want anyone stealing the banknotes and you don't want anyone actually counterfeiting the banknotes either. But there was a gang of thieves on the game, and this gang of thieves were awesome. They were fantastic. They managed to get to Waterlow's and they managed to pass themselves off as being genuine representatives of Banco de Portugal. And they placed an order for a further 580,000 of these 500 escudo notes. And Waterlow and Sons thought all their Christmases had come at once and they started printing them. And they printed them on the same paper, using the same presses, using the same dies as they had for the first job. They were virtually indistinguishable from the genuine article because they weren't actually forgeries. These were being made by the same people who made the genuine article. It got better. Having obtained their 580,000 500 escudo notes, these thieves went and opened a bank. They literally opened a bank back in Portugal as a way of laundering this money. Now, what do you do? What do you do if you're the Reserve Bank of Portugal and you suddenly realise that there are 580,000 500 escudo notes circulating in your economy? For one thing, you've got to worry about inflation because you're going to have a massive additional amount of currency flowing around the economy. Inflation's going to go crazy if you don't get them off the streets. The other thing is, currency is supposed to be backed by gold. This was currency that was backed by nothing. It couldn't be allowed to circulate as legitimate currency. So the only thing that they could possibly do, the only way to resolve this problem, was to get all the notes off the street. Not only the counterfeit ones, but also the real ones. Which meant that they had to get people to come in, hand in those notes, and have them replaced by the genuine article. And what this in turn meant was that the Banco de Portugal had to actually buy with genuine banknotes backed by gold. They had to buy all of these forgeries at face value. This was an incredibly expensive exercise for Banco de Portugal, but it was necessary in order to save the Portuguese economy. So can you see that this was a necessary mitigating action that they had to take? Something they had to do in order to stop the cancer from spreading, in order to stop their entire national economy from dying. They then sued Waterlow and Sons for essentially their breach of contract because they had allowed themselves to be duped, because they had printed these banknotes for someone who had no entitlement to receive them, and they had to foot the entire bill. The entire bill came to just over £600,000. Now this was £600,000 sterling in 1932. Converted to current 2014 values, that means that the judgment against Waterlow and Sons was 65.7 million Australian dollars. 65.7 million. That's an awesome heist by those crims. Unfortunately for them, none of them got away with it. But geez, wouldn't you take some risks for a $65 million payday? Fantastic case, one of my absolute favourites. The real point you need to take away though is that if you have to spend money in order to stop things from getting worse, if you have to spend money in order to stop the harm from spreading, then the money that you spend in that mitigating action is going to come back to you. You are going to be able to get damages in relation to that money spent. Next thing we have to look at is contributory negligence. Now, those of you who've done torts will be very familiar with both negligence and contributory negligence. Those of you who haven't done torts, I'm not going to give you the drum on negligence here because it'll just confuse what you're supposed to be learning about with contract law. In general terms, though, if there is a breach and the innocent party then does really dumb stuff that makes the breach worse, it's quite likely that they will only be able to obtain damages for that part of the breach which was not down to their own stupidity. The case that we look at is Lex Mead and Lewis. This is a 1982 case, reported in the appeal cases of that year at page 225. Now, in this case, a farmer has purchased a tow bar to put behind his trailer. To put behind his farm vehicle. The hitch on this tow bar is defective. It's unsafe. And the farmer knew it. So the farmer looked at this hitch and said, this is not safe, this is not good enough. And the farmer decided that he should go back and get it repaired or replaced, which was a good decision. The thing is, he didn't do it. He continued to use the hitch in the meanwhile without actually taking it back to be repaired. And he left it as it was for months. Eventually, the hitch came loose, the trailer came loose, the trailer tumbled free, crashed into a moving car, killed 2 people in the car, wounded a 3rd person in the car, and that 3rd person sued in tort. The farmer then turned around and said, you know what, this was not actually my fault. This was the fault of the people who made the hitch and made the tow bar. The court found that the farmer's contributory negligence in not having taken it back to get it repaired or replaced was in fact the key reason for the collision and the deaths. Finally, and I realise this has gone a little longer than most of our presentations this term, we come to the equitable remedies. Now, equitable remedies we know already, coming from the law of equity, coming from the Chancery law, we know that equity follows the law. So you're not going to get an equitable remedy if a common law remedy would do. So if damages will be adequate, if damages will be an adequate way to compensate the victim, to compensate the innocent party, then damages is what they will get. You will only get one of these equitable remedies if, for one reason or another, damages is not an acceptable way to deal with the breach. There are 4 types of these equitable remedies. Well, in fact, there's many types, but we're going to look at 4 of them. The first one is specific performance. Now, specific performance is exactly what it sounds like. This is where the court gives an order that says you must do whatever it was that you're supposed to have done under the contract. This happens quite a lot in real estate cases where somebody is meant to hand over title, for instance, to a purchaser, or they're supposed to make arrangements for an easement to be imposed or something along those lines. And the court can say, we're not going to just compensate them by money because money's not what the person wants. They don't want money. They want that block of land. Hand it over to them. That's specific performance. Pretty simple. Injunction. Injunction works in 2 ways. It can either make someone do something or it can prevent them from doing something. In most cases, when we speak about injunction, what we assume is that somebody is going to be prevented from doing something. So an interlocutory injunction, which is what you'll see most of the time, is almost like an emergency measure. You can jump in and get an interlocutory injunction to say, hold everything. We want this to stop so that there's no more damage done while we go ahead with the main case. If you have a look at the case of Castlemaine Tuohys in South Australia, this is a 1986 case reported in volume 161 of the Commonwealth Law Reports, commencing on page 148. It's not a contract case, it's a constitutional case, but it still shows how injunctions work pretty well. In this case, it was all about the container recycling schemes that go on in South Australia, and there were going to be amendments to the scheme, and those amendments were going to work to against the interests of Castlemaine Tooheys. Castlemaine Tooheys said, this is not constitutional, we want it to stop. They went for an interlocutory injunction to say, we want to hold this whole program up until the court works out whether it's constitutional or not. The court said no, because the court applies 3 rules when there's an application for an injunction. First, the court asks, is equity going to be appropriate? So, equity follows the law. You'd have to show that there's something wrong with just allowing the whole thing to go ahead and then later on claiming damages. Second, the court has to believe there's a serious question to be tried. So you can't rush out and get an interlocutory injunction just to make life difficult for your opponents. Third, the actual relief that's being requested in the interim has to be justified. So if what you're going to do is try and rush in and prevent an entire company from continuing to operate for 6 months while you go ahead and take legal action against them, then the remedy that you're asking for is unlikely to be justified in terms of whatever breach it is that you're trying to take action for. The next equitable remedy is rescission. Now, rescission has become an old friend. Rescission is a remedy that allows the court to set a contract aside and claim that to state that the contract is terminated. And generally speaking, rescission is also going to stand alongside the possibility of damages. Okay, so rescission simply is an order of the court terminating the contract. And finally, we get to restitution. Now, restitution looks a lot like damages because restitution involves the payment of money. But restitution and damages have quite different purposes. The purpose of damages is to compensate the innocent party. So we say, what harm has the innocent party suffered? And then we compensate them for that. Restitution, on the other hand, asks a different question. It says, what gain has the guilty party made? Because equity is uncomfortable with the idea of a wrongdoer making a gain from their wrongdoing. Equity is uncomfortable with what we call unjust enrichment. And so restitution says, instead of just looking at compensating the harm to the innocent party, we're also going to look at what gain has been made by the guilty party. And if necessary, we'll take that off them. Now, before you get too excited about restitution, let me tell you it very rarely happens. In its modern expression, restitution is normally only given in the 4 situations that I've outlined in the notes. That is, to recover money that has been paid by mistake, to recover money that has been paid when there is a total failure of consideration. Now, if you don't recall what a total failure of consideration is, go back a couple of weeks. Third is to recover money which has been paid in anticipation of the contract, but then the contract itself isn't formed. And finally, it's to recover money for work that's been done under a contract, but for one reason or another, the contract can't be enforced. So, for instance, if the contract has been frustrated and there's been a total failure of consideration, we would have effectively 2 bases for your claim in restitution. One would be the total failure of consideration. The other would be to recover for work done under the contract. So there's our 4 equitable remedies. What have we looked at this week? We've looked at a bunch of stuff. We start with the idea that the key remedy is damages. The idea of damages is to compensate the plaintiff for the harm that's been suffered. Damages are going to be assessed on the day of the breach, awarded once and for all. They can be awarded for the loss of an expectation. And then we get to our most important point. if you're looking at the calculation of damages, you must use the test in Hadley and Baxendale. If you don't use the test in Hadley and Baxendale, then I'm going to cry all over your assignment and cry all over your exam paper, and I'm going to take marks right off you, because you must use the test in Hadley and Baxendale when you're assessing the extent of damages. The court, we've learned, will enforce liquidated damages but not penalties, so don't go overboard. You can get damages to offset the costs of repair, rectification, mitigation. Your damages will decrease if you've negligently contributed to the harm yourself. And if damages just aren't going to do the job, we've got specific performance, injunction, rescission and restitution available in equity. So there we go, gang. That's topic 10. That's our common and equity law remedies. Next week, we're going to crack on and have a look at the Australian consumer law and the remedies which it sets out for breaches of the Australian consumer law. And that'll bring us to the point where the following week we can wrap up our study of contracts by looking at contracts which go over national borders. Have yourself a great week, and I will talk to you next week.